Good afternoon, I'm Jen Leach-Luckaway. Thank you again for joining us for Life and Death Matters. Planning for aging and end of life. This is the third of our 3 and a plus part. 3 and a, let me try again. 3 plus events. Goodness sakes. All right. Thank you for joining us once again. Today we have Rick Erb joining us. He will discuss finishing the title of his program is Finish Your Thoughts. He is a local attorney and will tell us all about wills, powers of attorney, that type of thing. Again, this whole series is put on by Vicki Kissick, who is with Gillette Memorial Services. I want to thank her again for partnering with the library. Fantastic event that we all about topics we all need to learn about. We will have one more event starting at 9 a.m. on Saturday, April 6th, which will be a day-long-ish symposium. 6 speakers are lined up that will again tell you all about life and death matters and things that we need to know. So we hope you join us for that. Please join me in welcoming Vicki Kissick.
Welcome everyone. I see some friendly faces and familiar faces. All friendly, some familiar. How about that? So I just want to tell you again, thank you for coming back. We have a great crowd here today. We set up an extra table. I'm sure we might have some people come in. I want to do a little housekeeping before we get started. We've been waiting on the pies until the end of the series, and that's just not fair. So we have casual conversation here. We're family, and if you want to get your pie first and your cookie first, and you want another piece of pie, that's fine. It doesn't matter. Nobody's judging. So we've got plenty of pie. All right. So I gave you a few items on your desk there in front of you that I would like for you to look through. We do have some new faces today. So with that, all of you that have not filled this out, please fill out the family planning form and then be ready to hand that in. We're going to have a drawing at the end for the book that I love. It's called The Butterfly Effect. So I brought it because I've been telling you every day that we've met, your life matters. And people will show up for you. I just want you to know that. And that's really what the butterfly effect is about, is how one person can change the world. And each of you have changed the world of people and family members that you've come in contact with. So we're going to do that drawing for that book. I did give you a flyer here called Meet Our Advanced Funeral Planner. And at the bottom of this flyer, you'll see my contact information if you need more information on getting your pre-plan done. Also, I would like for you to look, I guess, at this little pamphlet here. If you were here last week and you didn't get one because Darren at the cemetery ran out of them, please let me know. I will get you another one, or you can come on Saturday the 6th and we'll have more of these as well. Okay, and I actually have one left from, I don't know if she's here today because I don't recognize everybody, Susan Eichbush. This is yours.
Oh, thank you.
Okay. All right. So has everyone enjoyed the series so far? Yes. You can have as many questions as you need.
I thought that the information that was put out this afternoon was the information versus burial. Is that missing?
No.
Or is it tomorrow? Or
So the question is that this it was advertised as cremation versus burial, and I actually messed up the dates on the speakers. So we talked about that last week. Yes, but this week we'll have Rick here. But I also there'll always be information that you'll hear gleaning about that particular subject every Thursday. It's always come out, and questions can be asked at the end specifically. Yeah, we've done this the last 2 Thursdays. And so we've had those types of questions. If you specifically came with questions about that, we'll be able to have a Q&A at the end, and I'll answer those for you in this board. We've had two, this is the third one. So next Thursday, we're taking off, but April 6th, next Saturday, we'll be doing a symposium about the same subjects, but just a little more in depth of our speakers already know personal experiences.
Prevention versus prevention.
That will be one of the subjects that is addressed, correct?
Okay, thank you.
You're welcome. Yes, ma'am.
You can also watch the video.
Yes, thank you. We did have every Thursday's been recorded, so on the library website, you're welcome to go and watch that video as well.
Okay, thank you.
You're welcome. All right, so let's get started with today's speaker. I do have a,
Vicki, we have a
Yes.
question.
Yes, ma'am.
I just, that form you said, this is the first time I've been here.
yes, ma'am,
I don't see that form anywhere.
I will get you,
Okay.
for sure. I'll come around with that.
All right, thanks.
Okay, so our guest speaker today is Rick Erb, and he so graciously gave me a bio. The last 3 Thursdays, we've been introducing people by their obituaries. And I did not give Rick heads up on that, and I didn't want to scare him away, because he hasn't been with us for all of our Thursday meetings, so I didn't want to surprise him. But he did graciously give me some information I'm going to read here on Rick Erb, our next speaker. So, Rick is a 1974 graduate from Tongue River High School in Dayton, Wyoming. After graduation, he went to work as a coal miner in a few coal mines around Gillette. During that time, he operated mining equipment as a certified welder, a blaster, and finally became a production supervisor. While working full-time as a coal miner, he obtained his bachelor's degree through Eckerd College, a private liberal arts college based in St. Petersburg, Florida, graduating with honors in 1989. In the fall of 1990, Rick left coal mining when he was accepted to law school at the University of Wyoming. While in law school, Rick was a member of the Land and Water Law Review, also known as Wyoming Law Review, serving as one of its article editors during his last year in law school. He authored a case note which was published in the Law Review in 1992 and also co-authored a comment which was published in the Law Review in 1993. Upon graduation from law school in 1993, Rick began practicing law in Buffalo, Wyoming, and lived in that community for 10 years. The last 4 of those years, he not only maintained a private practice, but also served as Johnson County prosecuting attorney, where he represented the state of Wyoming as chief criminal prosecuting attorney in Johnson County, and also represented Johnson County and its elected officials in all civil matters. In 2003, Rick moved back to Gillette, Wyoming, where his main office is now located. He still has an office in Buffalo and divides his time between the 2 locations. Rick is a member of the Wyoming Trial Lawyers Association and currently serves the Wyoming Bar Association in various committees. Rick and his wife Stephanie live in rural Calma County and have 3 adult children, a few grandchildren, and several horses. When he's not busy practicing law, Rick enjoys playing fiddle and guitar and playing at the Bluegrass Jam at the Occidental Hotel in Buffalo on Thursday nights. Please welcome Rick Erb.
Thank you. Can everybody hear me okay? Is this microphone position okay? All right. Is there anybody here who already does not like me? Because I run into that. Been a lawyer since 1993, so I've managed to offend a number of people over the years by being adverse to them in matters. So anyway, this is free form. If you've got a question, I don't have a outline that I'm working from. I put together a handout that just gives you some general statements about what documents are frequently discussed in a state planning situation. Not everybody needs everything. Some people don't need any of it. So everybody's situation is different. Nothing that I'm giving you today is legal advice, because that's something that you get on an individual basis based on your particular circumstances. So I'm happy to answer questions to the extent that I can. And I do quite a bit of estate planning. That's become sort of a major part of where I think I'm heading with my practice as I get older in life. So I have some familiarity with quite a few of the things. There's some stuff that I'm not familiar with. The reality is that some people have really sophisticated assets, sophisticated lives, a lot of assets. And I normally work with people who have average average assets, not ultra wealthy people. That's not the clientele that I serve. There's a lot of questions that people have on their minds. Normally someone calls up and says, I need to get together and put together a will. The will is usually what's on people's mind. But that opens up the conversation for a lot of other things that people need to be thinking about as they go through life. One of the things that people frequently don't think about is the possibility of being disabled or incapacitated while they're still alive. And so we always talk about that. The situation is that if you become incapacitated, legally incapacitated, that means you don't have the wherewithal to understand what's going on around you and make informed decisions. You don't have the ability to make legally binding decisions on your own behalf. And neither does anybody else in your life unless you've given them that authority ahead of time while you're still competent. So some of the documents that can be very important are powers of attorney, healthcare directives are a couple of the primary documents for that. People are frequently, I meet with married couples, and a lot of them come into our meeting with the understanding that because they're married, they have all kinds of rights to make decisions on behalf of one another. And that actually is not true. By virtue of getting married, you don't have the authority to sign documents on behalf of one another. You don't have the authority to make healthcare decisions on behalf of one another. You don't have access to health records on behalf of one another. You can give each other that authority, but you don't have it just because you're married. So that comes as a shock to a lot of people. And a lot of times people figure it out too late in the game. After someone's already become incompetent is when they start to realize just how important those documents can be. If someone becomes incompetent and they don't have documents like that in place, nobody's going to have the ability to make decisions on their behalf unless they first go to court and become appointed as guardian or conservator or both. The guardian is the person who makes decisions on behalf of an incompetent person, and a conservator is the person who manages the assets that belong to that incompetent person. And it's frequently the same individual that gets appointed to both of those positions. But a guardianship action is to be avoided whenever possible because they're not simple, they're not straightforward, and they're not quick. They don't give you all of the kinds of authority that you automatically would have if you had a power of attorney in place. So getting a guardianship in place is typically fairly expensive. They don't happen overnight. They take time to get a guardian appointed. Locally in Wyoming, it's pretty common for the judge to require that not only the person who wants to get appointed has to hire an attorney to start that process, but the judge is typically also going to require another attorney to be hired to represent the incompetent person from their perspective so that somebody is advocating on that person's behalf so that the judge is satisfied that there's no monkey business going on, that someone's not trying to pull a fast one on someone. So they become fairly expensive to get a guardianship in place, and those can be avoided. I've never had a situation where we had to have a guardianship in addition to having the powers of attorney in place. The power of attorney typically covers everything that needs to be done. So I don't know specifically what the numbers are, but the majority of people, probably the vast majority of people, will have a period of incompetency while they're alive. In some cases, that can be a short-term incompetency. You go in for surgery, you're under anesthesia, you're incompetent. You can't make decisions on your own behalf if you're unconscious. And neither can anybody else at that time unless you've given them that authority ahead of time. So that's an example of a short-term incompetency. And then we've all heard or known someone who has had Alzheimer's, the long steady decline. And so there's a whole range of possibilities about why a person might be incompetent. But probably just about everybody is going to have some period of incompetency with those two extremes during their lifetime. So that's why powers of attorney can be very important. For healthcare decisions, the document these days is typically going to be called a Advance Healthcare Directive. A number of years ago, the AARP came in on strong-armed the Wyoming legislature, talked them into changing our statutes, so that we ended up with this document called Advance Healthcare Directive. And so that document is intended for health-related questions, health-related decisions. That's not the document that authorizes you to go to the bank and close an account or open an account, for example. That would be a separate document. That's typically described as a durable power of attorney. So the durable power of attorney is intended to cover just about everything other than healthcare decisions. And sometimes, for good reason, it's not the same document because it's two totally different concepts. But sometimes people have people in their family or in their life who have skill sets that are not identical in both areas. Sometimes they might have a daughter who's a nurse, and they want her making healthcare decisions because she understands healthcare, but they wouldn't trust her to balance their checkbook. And they've got a son who's a CPA, but they wouldn't take an aspirin if he handed it to him. So that they may have different people with different skill sets. They might want different decision makers for those two different areas. So those are a couple of documents that can be very critical, actually. They can be very critical that people oftentimes don't even know to ask about. A last will and testament comes into play when someone has passed away. The will can be perfectly valid, but it's useless while you're still alive. Nobody needs the will while you're alive. Nobody has any authority to do anything on your behalf under the will when you're alive. And even if the will describes someone being appointed as the personal representative of the estate, that alone does not make them the personal representative of the estate. First of all, you got to be in a situation where there needs to be an estate opened up. And not everybody's situation mandates the opening of a probate estate. That's going to be determined at the time when they pass away typically going to be based on the value of the assets that need to be dealt with. So back to the personal representative, even if the will says, I hereby designate little Johnny to be the personal representative of my estate, little Johnny has absolutely no authority until he's been appointed by a judge. He's got the authority to ask a judge to appoint him, but he's not actually the personal representative until a judge signs an order that does appoint him. So probate, what is probate? Some people know what probate is, a lot of people don't. Probate is a legal proceeding in Wyoming. It happens in district court. And the purpose of the probate in a big picture sense is to transfer the ownership of assets that remain titled in the name of the person who passed away. So big picture, that's what a probate is all about. That sounds simple enough, but it's not quite that simple. But the probate process is, well, if someone passes away, for example, and they've got a car that's titled in their name, that car doesn't automatically get retitled. Documents don't come fluttering down out of the sky to change ownership of that car. So that's an example of an asset that remains in their name. Same can be true for real estate or any other asset. If it's just titled in their own name, then the probate process steps in to transfer ownership to whoever's entitled to become the owner of it. That's an overgeneralization, but that's big picture. That's pretty accurate. There's plenty of criticism of the probate process. Some of it's legitimate, some of it's not legitimate in my experience. I've heard a lot of horror stories, people complaining about the probate process, and sometimes based on their own personal experience and sometimes based on something they heard from somebody or heard from somebody. In Wyoming, a typical probate is going to last around a year. They can go on for years. Sometimes they're wrapped up quicker than that, but they're not intended to be a fast process. They're intended to be a deliberate, purposeful, methodical process that goes through certain phases so that people who have a right to participate actually get the opportunity to participate. And it just takes a while to get some of those things done. And that's not a year of nonstop probate work where every morning you get up, oh, I gotta do probate stuff today. It's not like that. The process starts by someone, well, first, someone's passed away. But somebody who wants to be appointed as the personal representative of the estate files a petition with the court saying, please appoint me. If there's a will, then the will is part of the probate process. If there's not a will, then there's not a will. You can have a probate with a will, you can have a probate without a will. It's not the existence or the absence of a will that triggers a probate. So if there is a will, that starts a 3-month period within which anybody who doesn't like the will for some reason can challenge the will. Just because you've got a will doesn't mean it can't be challenged. There are reasons why a challenge to a will might be legitimate, and there's other reasons that are just completely not legitimate. One of the legitimate reasons to challenge a will would be that the person who signed the will was incompetent when they signed the will. And if that's the case, then that will is not valid, because you've got to have a certain level of competency to actually sign. You can sign a piece of paper, but if you don't know what you're doing, then that doesn't make it a valid will. So whether or not the person was competent at the time that they signed the will is one of the issues. Sometimes people get strong-armed into signing a will that's really not what they want. An example that I've seen personally, an elderly person who is not particularly mobile and is dependent upon someone to help them get around, help them to get to doctor's appointments, go to the grocery store, things like that. They can't do it on their own anymore. Sometimes that person will take them to that person's own attorney and have them sign a will that leaves everything to that person, when in fact they might rather have their property going somewhere else. But the message could be, look, you're going to sign this will or you're on your own. I am not going to be around to help you anymore. Well, that's a form of coercion. That's undue influence. And that's not fair. So that is another legitimate challenge to a will. None of this would happen just automatically. Someone would have to file a petition with the court to set aside the will. There would have to be hearings, legal proceedings going on for a judge to determine whether or not to set aside the will. The law gives a strong presumption in favor of a will being valid. So anyone wanting to challenge a will has to come up with some pretty compelling proof to show why the judge ought to set it aside. So that's one phase that is part of a probate process. Most wills do not get challenged, but occasionally a will gets challenged. But what is very common in a probate is creditors' claims. If the person who passed away owed money to people, those people have a right to be paid whether the person's alive or not. And so they can file a creditor's claim in a probate. And so they got a 3-month period as well within which to file their creditor's claim. If they fail to file a creditor's claim, then they might be out of luck later on trying to collect on that debt. They can't just pop up a year later or so and demand payment. The assets that are part of the probate have to be inventoried. That inventory gets filed with the court, and that's just a listing of here, dear judge, here's the assets that we're dealing with in this probate. Then those assets have to be valued. Somebody who's got the wherewithal to know what that asset might be worth offers a value. Sometimes those people charge for their services and sometimes not. It just depends on the circumstances. But we have to give the court a report of appraisal that shows what is the value of the assets that we're dealing with. And so those are documents that get filed along the way. Along the way, there may be bills that have to be paid. There may be reasons to challenge a creditor's claim. Sometimes a creditor, sometimes an individual who wishes they were a creditor thinks that they're owed money for some ridiculous reason sometimes, and they'll file a creditor's claim. Well, the personal representative can look at it and decide whether or not to allow the claim or deny the claim, or allow it or deny it. If the creditor's claim gets denied, that puts the creditor, that particular creditor is now on a clock. They've got to file a lawsuit to try and enforce their claim if they think they're owed money. So a lot of details can come up along the way to stretch things out, because you can't resolve the probate until you resolve all these issues. Toward the end of the process, once we've got everything dialed in, we know what we got for creditors' claims, what we got for assets to work with. We file a final report. It's typically the document that's going to be filed with the court, and that just gives the court a rundown of what has happened during the process of this probate. It gives an itemization of the assets that are remaining, an accounting of money that's come into the estate, money that's gone out of the estate, and a proposal to the judge for what the judge ought to order for a distribution of the assets that need to be distributed. Anybody who has a right to an inheritance in the estate, or creditors if they're not going to get paid, they've got a right to bellyache to the judge if they want to. So sometimes those get set for a hearing and everybody tells the judge what they've got to say, and the judge decides how it's going to be. And in the end, then the judge enters a decree that accomplishes whatever the judge has decided is right. So that's a pretty brief overview of the mountaintop parts of a probate. Criticisms that I've heard about the probate, one of them is, we got screwed, we got nothing. The lawyer got rich, the judge got rich, and we got ripped off. And maybe I've not seen that, but I guess theoretically it's possible. First of all, the judge gets a paycheck from the state of Wyoming. They get nothing out of any of the probates, so the judge doesn't get rich. The judge gets a paycheck just like normal, whether he's looking at this case or another one. In a Wyoming probate, the attorney doesn't bill by the hour, and the attorney doesn't actually bill anything until the judge has entered an order saying what the attorney's going to get paid. In Wyoming probates, the attorney gets a percentage of the value of the assets of the estate. So if it's a big estate, it's a bigger number. If it's a small estate, it's a smaller number. That number works out to around 2.5% on an average. That wouldn't be far off the mark. So 2.5% of the estate, that's kind of a long ways away from the lawyer got rich and we got nothing. The personal representative is also entitled to the fee. It's the same fee. It's the same computation. In addition to that, there's filing fees when we file a probate, when we file the report of appraisal. There's publication costs. We have to publish notices in the newspaper. There's costs for photocopies and postage and all that stuff. In a normal probate where there's no particular wrangling going on, if the personal representative takes the fee they're entitled to, that it's not unusual for the total cost of a probate to come in around 6% of the value of the assets. So that also is an awful long ways away from we got nothing. I have seen situations in which the family got nothing. That does happen. One of the primary reasons that happens is because the person who died owed a lot of money. And by the time the creditors' claims got paid, there was nothing left to distribute to the family. Well, you got what they had, which was a net nothing estate. They owed money. Sometimes because of lifestyle choices, they were in debt, or they may have racked up a bunch of medical bills right toward the end. There's any number of reasons why there might be a lot of debts. But that's not the probate process that let people down. It's just a life circumstance. Sometimes people don't have anything once they pass away. Another situation in which I've seen the family get nothing or close to nothing, everybody's fighting about everything. And we have to have court hearings and trials and battles in court. Well, congratulations, you got what you wanted. You wanted a court fight, and those are expensive. And by the time that got paid, there's nothing left. So pat yourself on the back, you got what you wanted. But otherwise, legitimate criticisms of probate are it's not fast, and another one is that it's not a private proceeding. It happens in district court, and the records of the court are public record. Anybody who's interested can go pull a probate file at the courthouse and look through it. If they're looking through the court file, what are they going to see? Well, they'll see the will, if there's a will. They'll see the names and mailing addresses of family members and anybody else who's entitled to notice in the proceeding. They'll also see the itemization of the assets, the values of the assets, and creditors' claims. So there's quite a bit of information that winds up in a probate file. For some people, that's not a big deal. They wouldn't care if their whole life story was on the front page of the newspaper. Other people are very private and they don't want anybody to know anything at all about their life. And that's fine. I'm not critical of either one. That's a personal preference. But the reality is that a probate is the opposite of a private proceeding. It's a public proceeding. But the reality is virtually all of that information these days can be found on the internet. If somebody is trying to hunt down information, it's available somewhere. So for people who are private by nature, a probate is not a way to accomplish that objective. There are ways to avoid probate. First of all, not everybody who passes away, there's not going to be a probate of everybody's estate. Under Wyoming law right now, I anticipate this number won't be going up for a lot longer. Right now, if the value of the assets are $200,000 or less, there's ways to avoid a probate. We've got some shortcut ways to deal with those assets if somebody's passed away and left behind assets that are $200,000 or less. If it involves real estate, we still have to file something before the court to deal with the real estate. But for personal property and bank accounts and things like that, we can distribute those out by way of an affidavit. And that is not a legal proceeding. That's just a document that gets signed by whoever claims to be the person or persons entitled to have those assets. With that affidavit, they can get cars retitled, they can get their hands on a bank account if that's the asset that we're talking about. If it's real estate, then we still have to file an action in district court. It kind of looks and kind of smells like a probate, but it's not probate. Nobody petitions to be the personal representative. It is just a request to the court to set over the property, the real estate, to the people who claim to be entitled to it. These days, it's kind of hard to find a piece of real estate that's less than $200,000. So, but those do come along. A lot of times what those are is mineral interests. Someone might have some mineral interest. Well, that's real estate. And so we would have to file an action to set that over. But sometimes mineral interests are just a few $1,000s, so you can easily be under the $200,000 mark. But if you're above $200,000, then that typically is going to mandate the need for full formal probate. Is there any questions? I've been around. Yes, ma'am.
Yeah, does it go into a probate if it's a husband and wife and one passed, then it has to go into a probate? Or does it just go to your spouse?
Okay, that's a great question. So the question is, if there's a husband and wife situation and one of them passes away, does it have to go into probate when the first one passes away? Is that fair? Okay. So it depends. Depends, and that's one of the issues on the handout that I gave you as well. How you actually own your assets makes a big difference on how things go when you pass away. There are ways to co-own assets, but there's several ways that a husband and wife, or even if they're not married, there's a couple of ways that people can co-own assets. And they have different results depending on the form of co-ownership. So the documents that show the ownership, for example, a deed to real estate or a vehicle title, or at the bank, the signature card, that's got a lot of information on it. It becomes important to know what happens when the first spouse dies. If they co-own everything, there's 3 different ways a married couple can co-own things. And it's not automatically one or the other. You got to look at the document to see what it actually says. The words on the page make a difference. It's not a concept. It's what do the words actually say. So let's just talk. There's times when people who are not married co-own property. But let's just talk about a husband and wife situation for now. One of the ways that a husband and wife can co-own property is called tenants by the entirety, also known as husband and wife. It's a form of co-ownership that's available not in every state, but in Wyoming it's recognized as a form of co-ownership. The result of that is if they co-own, let's just say a house, if they got a house and they co-own it as tenants by the entirety and one spouse passes away, the surviving spouse is the sole owner of that house. There's no probate, there's nothing needed to make that happen. It happened by operation of law the moment the first one passed away. The survivor became the sole owner of that house because of how they co-owned it. Now, we still typically file an affidavit with the county clerk to memorialize the fact that one of the spouses has passed away, so that in the land records at the courthouse, there's a record showing why there's now one owner. Otherwise, the world would still assume, going through the land records, they would say there's still two owners, because there's nothing filed to show otherwise. So the affidavit of survivorship is the document that clears the title up. The affidavit of survivorship does not change the ownership. It just memorializes the fact that there's now one owner. So that is a way that a husband and wife can co-own property. Unmarried people cannot co-own property as tenants by the entirety.
So Rick, then the wife would have to take a death certificate to show that that person had passed away, and where do they get the affidavit? Do they have to go to hire a lawyer to do that?
Typically, they're gonna need to hire a lawyer unless they know what they're doing. Sometimes people have some familiarity with the documents. They don't, it's not a form that you get at the courthouse. They don't provide legal documents for you to make such things at the courthouse, and they can't, by law, they can't give legal advice. So the affidavit of survivorship is typically gonna be prepared by an attorney. That would be the practice of law, but sometimes people are able, they've seen one, so they just copy it and it carries the day.
And then they would go to the courthouse with this affidavit and the death certificate and say, you need to take my husband's name off the title, or?
So that's a great question, Rita. The reality is there is not a title in the written sense to real estate. There is a chain of documents that come down to the present that show who the owners have been and what they transferred and to whom. So in a legal sense, title to real estate is kind of a concept. It's based on the totality of the documents that have been filed over the years. It's not like a car where you have a title. So ownership is changed by transferring with real estate. It's a deed. The document's called a deed. Yeah, that's how you would sell a piece of real estate or transfer ownership interest is with a deed typically. And so the concept of title when it comes to real estate, it's not as simple as having the courthouse change the title like you would with a car. The courthouse will issue a new title. What happens when you file the affidavit of survivorship, the affidavit has attached to it a certified copy of the death certificate. And so that gets filed with the county clerk. The county clerk doesn't really track ownership. They record documents, and the documents are there for people to look at. The assessor does track ownership, and so after a while, it takes a while, once a document has been filed, it takes a while for the assessor's records to get updated. But the assessor would eventually update their records to show that now the surviving spouse is the sole owner. That doesn't change the ownership. That just means that the courthouse records have been updated to match reality. Reality happened when the first spouse passed away. There was one owner at that point because of the way they co-owned it. Any questions on that one before we move on?
How about the importance of the deed, then file with the courthouse, they vow, the clerk, about the survivor, which does not have nothing to do with the spouse. So then, in case of death, this document that addresses the beneficiary, this beneficiary can transfer to a third party?
So
With what you're talking about?
I'm not entirely clear on what your question is. Help me understand.
For example, the owner of the house, a house, okay? So in the deed, there's only one person, not the spouse, nobody else. But the person, the individual, file with the clerk. the beneficiary, a beneficiary that doesn't have nothing to do with the marriage. It's a family, blood family. So if the owner of this house passed, the beneficiary be able to give the affidavit of transfer ownership to a third party?
So let's talk through that and make sure I'm understanding. You're talking about a situation where, we'll just use an example of a house. There's one owner of the house,
Yeah,
and that one owner passes away.
has a beneficiary, one beneficiary,
Okay,
and that's in the clerk. It's on the document, and it comes in the tax, the two person, the owner and the beneficiary.
But the
So-
beneficiary is
But the
not the spouse.
beneficiary does not need or want the house or the property. Does the third party be able to get an affidavit from the beneficiary to transfer the ownership without complication or probate?
yeah, I'm not sure I'm following. I'll talk about some other stuff and see if that answers your question as I
Okay.
go through some, because
I'm
I'm not,
interested about this because
Yeah.
I did this.
okay.
Okay. I put a beneficiary that is not a marriage relate. So it's a beneficiary, it's a blood related. But the blood relate does not want that, and I cannot change now.
Okay,
So after death, has an instruction to the beneficiary transfer to this person. Is this illegal or go to probate?
I don't know. I'll do some more talking and then we'll see if that answers your question. Is there a question in the back?
Yes, so, for instance, as an example, you have a mortgage that's in both of your names, and one spouse passes away, and, it was presented to me that then I provide a document, the death certificate, and then therefore I would be the successor. Do I still need an affidavit of survivorship?
So the mortgage is a little bit different animal. A mortgage is not evidence of ownership. A mortgage is a lien against real estate.
Okay.
So if, let's say there's a husband and wife and they get along together as husband and wife and they buy a home and they sign a mortgage in favor of the lender, that gives the lender a security interest in the property. If they don't make the payments, the mortgage holder can foreclose on the property, force the sale of it. That's one example, but dying is not a violation of a term of the mortgage. You haven't violated the mortgage by dying. That happens.
Okay.
The lender would still have a mortgage against the property. It's unaffected by the death of the first one. It's not unusual, I've heard of it happening, where a mortgage holder will find out that one of the co-owners has passed away, and they want some document from the surviving owner committing that, oh, this is your mortgage is still good. Up yours. The mortgage is still good. If a lender wants something from you after you got your loan, I'm not sure that you ought to just roll over and give them what they want. It's not a violation of the mortgage for one owner to pass away. And it doesn't invalidate the mortgage that's in place. That mortgage is still in place. So the lender has still got their security interest. The affidavit of survivorship, I don't think it needs to be provided to the lender. If the lender wants it, okay, why not? I don't care. But the lender is not typically going to be the one that's asking for an affidavit of survivorship to be filed. The reality is affidavits of survivorship frequently don't get filed. People don't know that they should file an affidavit of survivorship. It can be filed later on by someone else. But if they go to sell the place, they won't be able to get title insurance until they file an affidavit of survivorship. The title company is going to have that as a requirement. In order to issue a title insurance, they're going to require an affidavit of survivorship to be filed with the county clerk. So sometimes that's the trigger that gets the affidavit filed. Most people don't understand that they at some point somebody's going to have to file an affidavit of survivorship. So yes, ma'am.
Notification. You talked about bills that creditors would need to find out that somebody died. What kind of notification has to be done.
Okay, so one of the details that we need when we're working with someone in a probate, to probate an estate,
Or maybe not even in probate. So, they had a trust, they don't have to go through probate or anything. But do you have to put a notice in the paper saying somebody died? So if in case they
No.
owed money?
there's not an automatic requirement to file or to publish anything in the notice just because someone has died. In fact, I don't know of any reason to do that just for that reason alone. The obituaries are get published, and sometimes
But if they don't have an obituary, they chose, I don't want an obituary, I don't want anything.
Sometimes there's a notice in the paper that someone has passed away, even if it's not an obituary. But there's no duty to publish a notice in the paper, a legal notice that someone has passed away. That is almost always going to be published in the paper because somebody has opened up a probate.
Oh.
That is part of the probate process, is publishing a notice in the newspaper. Now, there's also provisions for publishing a notice in the newspaper when we're administering a trust. We can, it's optional, it's not mandatory like it is in probate. In probate, it's mandatory. You have to publish a notice in the paper for 3 weeks. With a trust, you can publish a notice to creditors. That can provide some protection from creditors popping up later and saying, pay me now. But with a trust situation, it's frequently, we know who the creditors are. In a trust situation, it's not unusual to know who the creditors are. But there's always the possibility that there's something out there you just don't know. But when we send out notices of the probate, is usually where that goes. We've already got a list of the known creditors from the personal representative. They let us know who money is owed to, who the bill, they watch the mail and see who our bill's coming from. So we send a notice of probate to everybody that we can think of who might pop up and say money is owed, even if we're pretty sure it's a zero balance. My practice is to send them a notice of probate because that's the cost of a stamp. And that puts them on a clock to file a creditor's claim. We don't have to worry about them later showing up and saying that they were owed money that we didn't know about.
So if you, let's say the hospital, you're in the hospital and they told me that they can take 2 years to send you a bill. So 2 years later, they're gonna send a bill. Can you just say, no, we sent you?
Yeah, if we send them a note, well, nothing stops them from trying, but
Right.
we can say pound sand. If we have sent them a notice of the probate and they blow it off, they do so at their own risk. And yeah, the hospital billing, I've seen situations where they are running way behind. They send out a bill months after someone has died for the first time. And nobody knew that this new bill shows up out of the blue. Nobody knew that it was even out there. So having the probate going on and sending them a notice is a way to put them on the clock to step up and give us the bill or forget about it later on. It sounds simple enough, but I'm confident they'd pay their attorneys good money to try and fight it out. But that's one of the things that we do. Now, we publish the notice in the newspaper, and it's interesting to know that we publish the notice in the newspaper, and that's intended to put the world on notice that there's a probate going on. But that's not going to work for creditors whose identities we know or could discover through the exercise of reasonable diligence, whatever that is. So we have to actually send notice to the creditors that we know about. We don't get to just publish it in the newspaper and hope they don't ever see the newspaper. They might be in New York. It might be somebody in New York with a credit card company or something doesn't get the Gillette paper. So if we know that there's a creditor out there, we have to send them actual notice directly to them. We can't just rely on the notice that's published in the newspaper.
So it would be best just to send a letter to the hospital or whatever saying this person died.
Well, if we're in a probate situation, that's going to happen. That will happen. But if there's no probate going on, that there is no clock that gets started just by sending a letter to the hospital just because someone has passed away. That does not start a clock running. That clock that starts running is in a probate proceeding only. That's not just because an individual who's wanting to make sure, just sends a letter saying, please let me know. It's only in conjunction with a probate that they get put on a clock. Does that make sense?
No, but it's a legal thing, so all of it doesn't make sense.
Well, I can send a letter to the hospital right now and say, please let me know within 30 days what I owe. And they can look at it and say, we'll let you know when we feel like it.
Mhm.
There's nothing that puts them on the clock. If I'm administering a probate estate and I send them that same letter, this person has died, let us know what's owed, and they blow that off, that's fine. At the end of 3 months, they might have blown it off too long because of the probate laws. Probate laws don't apply unless we have a probate going on.
Understand that.
Yes.
We were always under the impression that it depends on how you set things up. Like if the title to your house, if that is in both husband and wife's name, and it needs to say and or rights of survivorship, does that keep it out of probate? And what about bank accounts and stuff like that? Should you have someone else's name on it? Is that will they automatically take possession of that because their name is on the title or on the account?
So let's talk about that. Let's just use the first example that I talked about, husband and wife co-owning a piece of, owning their home as tenants by the entirety. That means both names are on the deed, and it says as tenants by the entirety. Those words have to be in the document. Those are magic words. It's not being married that makes that a form of co-ownership. It's having those words in the document. Those words have to be in the document. And so if it says both names as husband and wife or as tenants by the entirety, one spouse passes away, the survivor is the sole owner of it at that moment.
Okay.
Another form of co-ownership would be joint tenants with right of survivorship. And you don't have to be married to co-own as joint tenants with right of survivorship, but you can be married and co-own as joint tenants with right of survivorship. So same result, if one of the co-owners passes away and it says joint tenants with right of survivorship, those words are in the document, the surviving owner is the sole owner at that point, because that's the legal result of co-owning in that fashion.
So then, Rick, when they go to sell that home, they get approved that that first person passed away.
Yeah, that'll be the
Because
purpose.
otherwise you need his or her signature to
Correct.
sell that home.
Right. Yeah, and you're not gonna get a signature from a deceased person. So that's the purpose for the affidavit of survivorship. That satisfies that requirement. That explains that there's only one owner now and why.
So then you would still need the affidavit. She could say it's time to sell. Her husband's passed away 5 years ago. She couldn't just take a death certificate in and sell the home. You need the affidavit.
If you got a buyer who's willing to buy it, that's their problem. They're gonna have problems later on, but the trigger is normally in a transaction, to buy a real piece of real estate, normally that's not a just walk in, hi, I wanna buy your place, here's a check, and you become the owner. If somebody's getting a loan, the lender's going to require title insurance for the mortgage, and the standard real estate contracts in Wyoming will have a provision in there for the provision of title insurance. And the title company is going to require the affidavit of survivorship. They're not gonna issue title insurance unless the
Buy a
affidavit.
death certificate, that's, a death certificate won't.
A death certificate is part of what you need, but that will not fix it, not by itself. You need the affidavit.
And you have to consult a lawyer to get that affidavit.
Unless you know what you're doing, yeah.
Okay.
And some people do, I'm not making light of that, but these are legal proceedings with rules, and if people know what the rules are, they don't necessarily have to have an attorney drafted. Most people don't, and most people don't have a reason to get up in the morning and say, let me study up on stuff I never wanted to know in the first place. So that's the purpose for consulting with an attorney, because they've got the training, typically not all attorneys in all areas, but attorneys who handle probates, attorneys who handle real estate are very familiar with these concepts, know know exactly what to do. So that's usually gonna be where a person goes. You don't go to the courthouse to get an affidavit form. They don't have them for that. So, and my experience, the title company doesn't have them either. They're in the business of issuing title insurance, not practicing law. So, yeah, like it or not, sometimes you gotta consult with an attorney. People can try and do it themselves. Sometimes I've seen people go to great lengths to do everything they can, never to set foot in an attorney's office, and they wind up making the situation messier than it was, because they just don't understand what they're doing. And that's not a criticism, it's just an observation that there's an accepted way of doing things because that's what the law calls for. And if you're unfamiliar with the law, then that's where the lawyer's knowledge and expertise comes in. Yes, ma'am.
So if I put my 2 kids on my, with right of survivorship, whatever that's called, on my house, and I'm on there too, and then I die, and then they're going to have to do some legal work to get it, my name off of it and their name on it. Is that the answer?
Well, the answer for me is I'm never going to help you get in that situation in the first place because I won't help people do that. I've had a lot of people over the years, they do unnatural things with their assets in order to prevent their kids from having to deal with a probate. And they wind up in a bad spot later on because they've made their kids a co-owner on their assets. And then either, a number of things can go wrong. They no longer own their asset. In the case of a home, they no longer own their home. They co-own their home. And if their kids think the home ought to be going a different direction than mom does, mom wants to go to Arizona. Sorry to hear that, Mom. We're not selling our house. You can't do it.
Oh.
You've lost control of your assets. Or if your kids wind up with creditor problems, that's an asset of theirs, and creditors can come after it. And so you've made your kids' problems your own problems by making them co-owners on your assets. There's other ways to handle that, but that's a way that I just won't help people do because I think it's a bad idea.
If it's in a trust, does that save that?
A trust is a way to avoid probate. Yeah, if the real estate is in a trust, and if the trust is a valid trust, the name on a document doesn't make it work. The document itself and what it says inside the document determines what it actually is and what it actually does. But if real estate is in a trust, then typically that's never going to see probate because the trust doesn't die. The owner of the real estate in this case would be the trustee of the trust. If the trustee passes away, the trust is still in existence and a successor trustee steps into those shoes as trustee and still manages those same assets. So the trust doesn't die just because the person who made the trust passes away.
So now we're down to the trust thing. So the safest thing is to make sure you have all your assets in the trust.
That is a way. To know what the safest way would require me to have a crystal ball to know what the future is going to look like. And so we don't have that. It is a way to own assets. It is a way to avoid probate for those assets. That doesn't automatically make it the best way or the safest way. There's some misconceptions about what trusts actually accomplish. Some people have the trusts I'm talking about are known as living trusts or revocable trusts or grantor trusts. Those are different words for the same thing. A living trust is a trust which the people who set up the trust retain the ability to alter, amend, or revoke the trust at a later date. So it's not something that they carved in stone and that's it for all eternity. With a living trust, one of the features of that is having the ability to change it later on if you want to change it. But if it's not changed, then it says what it says when they pass away, and the trust becomes a way to avoid probate for the assets that are actually in the trust. Have I shot past your question at this?
Well, I'm just not gonna die.
So don't put your kids'
Yeah,
so don't put your kids' names on your
on your property, because if I die and they have debts, it can be in that. When my dad died, he owned a small ranch. I'm an only child, and it was joint tenants' rights of survivorship. I don't remember any problem at all. I don't,
Probably don't.
so, yeah, maybe I don't know.
Right.
So I don't know, he had my name on the deeds, I mean, the deeds, the bill for the taxes would come to me and him.
Yeah.
So,
No, in your situation, the way it played out at the end, it worked. But going into it 20 years earlier, there's no way to know how it's going to play out. So there's risk in whether or not that's actually going to be a good idea. On top of that, people don't always die in the right order. Sometimes the kid dies first. So relying on the right of survivorship, that's not estate planning, that's estate guessing. That's parents guessing, well, I'm going to die before my kids, and that doesn't always happen. Jen?
So in the situation that, similar to what you were talking about, if the parents deed a property to the children, they die, they don't really want the house. I'm assuming that was not a wise move, but how do they have to, they don't want the property? I'm thinking about capital gains type things. Is that a thing? And how do they, can that be corrected before they pass?
It can be corrected before they pass if everybody's on board to undo what was done. If mom and dad, or let's just say mom transfers the property so that she's a co-owner with kids, and the kids are co-owners right then and there. And later on, if the three of them, there's two kids and one mom, if the three of them want to undo that, they can undo that and transfer it back to mom. But then it's back in mom's name. And so, but to your question, if there's three co-owners, mom and two kids, and they have the right of survivorship and mom passes away, the kids are the owners at that point. They were co-owners before with mom. They were co-owners while she was alive. But when she passed away, her ownership interest expired with her, leaving the two kids as co-owners. They're the owners. They can sell the place if they want.
but if one of them's in debt a lot, that affects,
You better get out of debt then. I don't have an answer to that. If people are in debt, they're in debt.
that's their problem, I'll be dead.
Right.
So living
Let them
trust
figure it
is
out.
still the best way then.
I get the situation I'm talking about is not co-owners even, but deeded to all of the kids. And then do the kids have to keep that live in the property for a certain amount of time to avoid the capital gains on a 100-year-old house, or not 100, but close
Yeah,
to
you're
that?
asking really great CPA questions.
Okay. Wrong professional.
No, those are, the lines get a little blurry sometimes. I try to stay in my lane. I don't give tax advice. I'm not qualified. Capital gains, that's a federal tax question typically, and so you should consult with a CPA with tax questions. I can talk all day about the legal results of a lot of things, but the tax consequences, I'm not qualified to talk about most of those. Yes, ma'am.
So when you're looking for a lawyer to set up an estate, what initials behind their name, what kind of lawyer are you looking for?
You won't necessarily see initials behind their name because the initials behind the name on a lawyer typically don't tell you anything unless it's a junior or senior or third or something like that. It might tell you that they had a dad with the same name. With a lawyer, there are certain credentials. There's not any particular specialization certifications in Wyoming. So it's not like you can look at the Wyoming State Bar and say, oh, well, here's somebody who is certified by the State Bar to do estate planning. The State Bar does not certify practice areas like that. They license or they don't. Well, the Supreme Court technically licenses, but the Wyoming State Bar has a website, and on that website you can search for attorneys by area of practice. That's not a certification from the bar that they're competent. That is a listing of people, of attorneys who have said, please include me in the listing for estate planning. So you're not getting a certification that they know what they're doing, but you're getting their statement that that's part of what they do. Yes, ma'am.
For instance, if you have a home in two different states, you have to have two different lawyers, or kind of a lawyer from Wyoming work with you on your home in Montana.
For estate planning purposes, Typically, you're going to do your estate plan in whatever state is your primary residence. The estate plan can be effective in other states, but there may be local questions having to do with special areas with regard to the asset located in that state. But I'm perfectly comfortable doing an estate plan for Wyoming people who have a home somewhere else. But it depends on what we're doing. If we're doing anything with that home in another state, they might need an attorney who's licensed in that other state to deal with that while they're still alive.
If it's just a transfer over to the children.
Correct. Yeah, and if, for example, a person owns real estate in 2 states when they pass away, you can wind up with a probate in Wyoming and a probate in that other state too. You can wind up with multiple probates going on. The Wyoming probate is not going to deal with real estate located in other states. And other state, if there's a probate going on in another state, they can't transfer the ownership of real estate in Wyoming. The Wyoming courts have jurisdiction over the Wyoming real estate, and the courts of the other state have
So
jurisdiction.
you don't want to have a probate. You want to try to avoid a probate in that situation.
Well, yeah, that's one of the factors that can factor in favor of having a living trust if you've got real estate in more than one state. Because then you're going to avoid the probate in both states with the real estate. So that's one of the factors that can be in favor of creating a trust.
I had a similar, I was thinking about the same thing Peggy was. I've lived here for most of my life and recently inherited some land that my parents had on a farm in Minnesota. So it was in a living trust, so there was no probate. It was just slick as it could be. They just put our name in the deed, put it in the courthouse, and that's our ownership. We pay our taxes, we have cash rent, that kind of thing. Now, when I hate to admit that I haven't done my own living trust or will yet. So do you have to do it? Do you have to do part of it in both states? Or if I live here in Wyoming, it would take care of what I would need to do with the land so that my children inherit it from Minnesota, that part of it? Or what do I do?
In my experience, having the one trust in Wyoming is just fine.
And it takes care of all that.
Yeah, you probably need a Minnesota attorney to draft the deed to transfer the ownership into the Wyoming trust. Technically, the trustee of the trust is the owner of the property, not the trust itself. The trust is a piece of paper. But we use the terminology that the trust owns it just as a shorthand. So the transfer of the real estate would be based on Minnesota law because that's where the land is located. But it would be transferring ownership to the trustee of the Wyoming trust. And the Wyoming trust would be just fine for managing that if something happened to you. The trustee who is with the Wyoming-based trust would still have authority over all of the assets wherever they're located. In a general sense, there may be specific situations where that's not correct, but in a general estate planning sense, that is correct. There was a point I was about to make and I lost my train of thought a while back. People have the impression sometimes that these living trusts protect their assets. They do not protect their assets. They're not intended to be asset protection trusts. They're for estate planning purposes. If you've got a creditor right now, that creditor can reach your assets. If you put it in a living trust, that creditor can reach the assets in that trust. That's not the purpose for those trusts. Those trusts are intended to be used for estate planning purposes, avoid probate, manage assets on behalf of beneficiaries who might not be competent to manage their own assets later on. There's all kinds of reasons why an estate planning type of a trust, like a living trust, would be perfectly appropriate, but creditor protection is not a feature of a living trust. The people instinctively think, well, I want it to be. Well, that's nice. It's not. An asset protection trust, once people start to understand what those are, most people don't want anything to do with them, because the single most important feature of an asset protection trust is you have to lose control over that asset. And you can't have control over the trustee of that trust. A lot of those trusts get set up offshore in other countries that don't recognize judgments in the United States. there's all kinds of sophisticated things that can come along to try and have an asset protection trust. So if you've got a ton of money and you don't mind losing control over 100 million or something, sure, put 100 million in an asset protection trust and hope for no need for it for a rainy day. But what most people who come to me do not want to lose control over their assets, and they want to maintain flexibility with what they do with their assets. So you can't protect those assets from creditors' claims, other than by paying your bills. That protects you from creditors' claims if your bills get paid. And sometimes you wind up in a bad situation that you didn't create. You can have a health event, you've got all kinds of bills. That's reality for all of us, that can't happen. But this kind of an estate planning trust is not intended to protect assets from creditors. That's not a feature of this kind of trust. Yes, ma'am.
Kind of on the same line, so if you have a spouse or a parent that does have set up revocable trusts, and they have those assets, and they need to go into a long-term living situation, how do you protect yourself from draining all of your assets before, rather than Medicaid or Medicare picking that up? Like, what do you do?
You get an appointment with Allison Gee at Tom Lubnau's office.
Okay.
And talk to her or talk to Tom.
Okay.
They both.
That's where our trust is set up, so.
They are both taking on Medicaid planning issues.
Okay.
That's a real specialized area. That's not estate planning. Medicaid issues are not universally applicable in estate planning situations.
Okay.
So for those kinds of.
Do you know if that is something, I'm guessing that's something you tackle when you are in that situation. It's not something you can prepare for ahead of time?
You better prepare ahead of time.
Okay.
If you see it coming.
Okay.
If you see it as a possibility, that the big one is nursing home.
Right.
Because that ratchets up around 10,000 a month these days. So that'll gobble through a lot of assets really quick. There are ways to shield some assets, but one of the primary ways, when I started practicing in 93, there's been this notion of a look-back period. When somebody needs the nursing home, when they fill out the application for Medicaid, there's this look-back period. It's now 5 years. It used to be 2.5 when I first started. Have there been gifts made during that period of time? The person who's needing Medicaid, have they made gifts? Because it became a real common thing in the early days of Medicaid. Well, I'm going in the nursing home. I'm just going to give all of my assets to my kids now. I'm broke. I qualify for Medicaid. Well, you intentionally made yourself broke, and the government cried foul. They said, we're not in the business of paying for the nursing home for everybody. So they developed this look-back period, and if you've made gifts during the look-back period, that can disqualify you from receiving Medicaid. That's not a good situation. So for some of that, for people who want to, if they've got a ton of assets and they want to carve off a bunch of it and give it to the kids, that's fine. That's their call. As long as they've got enough to make it for 5 years before they go in the nursing home. Because at that point, they better not have any gifts during that look-back period. I haven't heard any chatter about extending that 5-year period. That's kind of a long time to have the nursing home on the horizon. 5 years out, that's kind of a long look. So yeah, I would say there's other Medicaid attorneys in Wyoming, but most recently, Allison and Tom they've taken some serious classes to get up to speed on some of those issues. So we got someone local in the community now that can take a look at that. So let me,
Sorry.
Jim.
Well, this isn't really a question, but, so we need an attorney, we need an accountant, and we need
Funeral director?
we need asset management. Is there any teamwork involved that you guys all get together and help us out all at once so we don't go 3 different directions?
Can be. There is plenty of times when it is really helpful to have an accountant in the conversation about how to set up an estate plan, and an investment advisor to talk about it, and insurance agents. Oftentimes insurance can be a very important part of a comprehensive estate plan. So having the different disciplines involved in the process can streamline things later on when it goes into effect, because we've had that input from the beginning. A lot of times people just don't want to have that kind of a global conversation more than one advisor. But there's plenty of advantages in many situations to do it.
Seems logical to me.
Yes, ma'am.
Short question, can a rest home take your life insurance?
I don't know, they can take your assets.
Is that an asset?
Well, here's how it works. They send an invoice. They expect the invoice to be paid. And if you can't pay the invoice, then you can get kicked out.
Well,
If-
it did.
Yeah, because they expect to be paid. The way that they get paid is either by private pay or by Medicaid. Typically, those are the ways. If you have assets, then they're gonna want you to fill out the Medicaid application process, probably, at the nursing home. I haven't had a conversation with anybody at the nursing home for years, but my experience in the past was that they expect you to fill out the Medicaid application so that they get a sense for where things are at.
So I die but I have life insurance, and so then, do my kids get it or do I get it? I mean, I'm dead, sorry. I mean, do my kids get it or does the rest of them get it? Sorry.
Well, if you've got life insurance, you should have beneficiaries designated on that policy.
I do.
Not everybody does, but normally you do. And normally the insurance company is gonna get out their beneficiary designation form and say, got your name on it.
Right.
We're gonna send you the money when you give us a death certificate.
Is there a difference between term and whole life?
You should ask an insurance. There is a difference, yes.
Yeah, there is.
I'm not qualified to
So I-
talk about
So I
those
would need to
differences.
see LCG or Tom Lubno, or the,
If you got
Insurance.
questions about Medicaid, yeah, I will,
Oh, okay,
or nursing home,
not there yet, all right.
yes, ma'am.
Okay, say you've got a living trust and you've got beneficiaries that are going to take over when you die. So what happens if your beneficiary or whoever you set up dies first and then you don't have anybody to monitor this? Is there a company that handles trust helping people, or do you turn it over to your attorney that set up the trust, or what happens if you have nobody to monitor your trust stuff while you're still alive? You know, they've all passed away or whatever.
So let's talk terminology right quick. A beneficiary is not a trustee. A beneficiary is a person who has the right to receive the benefit of the assets, but not the control.
Trustee person has.
So the trustee is the one who manages the trust for the benefit of the beneficiaries. And so if you are the trustee of your own trust and you become incompetent, hopefully the trust document spells out who the successor trustees are. If it does not, or if there was one named and that person passes away or is just not interested in doing it, beneficiaries can petition the court to appoint a trustee if they can find someone who's interested. There are banks that do trust services. First Interstate Bank, First Northern Bank, First National Bank have trust departments. There's others. But they're not automatically interested in being trustee on all trusts because they have a certain threshold. There's got to be significant assets for them to manage before they'll be willing to take it on. Because their fees are going to be there whether there's a lot of assets or not. And their fees can gobble up what's in the trust. And so they don't want to wind up in a situation where the beneficiaries are upset because there's nothing left because their fees got paid. So sometimes finding a trustee can be a problem. But in that case, that's probably a fairly small trust. And there are provisions for terminating those trusts and distributing the assets out to the beneficiaries. And so that in some cases, there's just no economic reason to maintain the trust.
Okay, so if you reach that point and you are still, I mean, if you're not able to make that decision, then what? I mean, then do the beneficiaries, I mean, say you're still alive and you're in the nursing home, for example. Well, I guess you probably don't have to worry about it, because the nursing home's gonna get it all.
Yeah, they'll be sending out bills that'll gobble it up.
Okay, never
Best
mind.
thing to do is
But that brings up a good point. If you are still alive, you are still the beneficiary of the trust. You might have successor
Here's what I
beneficiaries
found.
named, but the kids are not beneficiaries while you're still alive. The trust is typically going to be set up so that it's for your benefit as long as you're alive, even if you're incompetent. But once you've passed away, that's when they would become current beneficiaries. And, but prior to that time, they just got this expectation that one day I'm going to be a beneficiary of the trust, if there's assets left by that point.
Rick, going back to the power of attorney.
Yes.
Now, I've noticed that people do put their final wishes in there. Now, is that binding? Because once death occurs, typically that power of attorney stops. But if they put in their final wishes, burial, cremation, or whatever, is that a binding legal document?
It can be, it depends on which document and where it's buried. When we're talking about powers of attorney, typically we're talking about not healthcare decisions and not disposition of remains normally. Normally, a power of attorney document will terminate upon death of the person who made it. With an advance healthcare directive, there was, when the statutes were first enacted, I don't know when that was, about 2005 or so, that created advance healthcare directives. There was a form in the Wyoming statutes, which it didn't come right out and say that this is the mandatory form, but it did say that after a certain date, it was optional. So I think it said it without saying it. I think the legislature was passive aggressive on that. So in that form, there's provisions for what to do with my remains. And so the
In the
agent,
power of attorney or advance
the
directive?
healthcare directive.
Okay.
So, it depends on what specifically is in the power of attorney document. It's not a concept. It depends on what the words are that are in the document, what it actually says. So there are provisions, somebody's got to have authority to make decisions about disposition of remains. And so for purposes like that, there could be some carryover after death, but that's typically going to be in a healthcare directive is where that's typically going to be these days. Every attorney comes up with their own forms, and I shake my head sometimes about forms that attorneys are using that are 40 years old, but they're still using them. But primarily, the healthcare directive is going to be where we're going to be seeing discussions about what to do with my body after I pass away.
And that's a legally binding document.
Well, ultimately, that's a decision for the judge to make if people are arguing. A lot of times the argument never gets made. People look at the document and say, well, we're just going to make that work. And sometimes someone in the family is a holdout and they just don't like what it says and they want to fight about it and they'll file a lawsuit to try and get things their way. And how it plays out in court, I don't know. The document doesn't mandate the result that's in the document.
So then the document for final wishes would be that advance healthcare, not in a will, or will is possession, so probably.
Yeah, I've
That's
seen.
where it would go.
I've seen different documents that have it in different places. Sometimes I'll see in a last will and testament, I'll see a discussion about what to do with my body. My experience is that's not a great place to put those instructions because normally people don't go running for the will right away when they're making funeral arrangements. But if they've been making healthcare decisions along the way, they might have been looking at the healthcare directive, and if there's instructions in there, they may have all the information they need to know what the person wanted. And realistically, the Advanced Healthcare Directive is a statement of here's what I want. Does that make it binding? It says what it says, and people don't want to give effect to it. If there's 3 kids and all 3 kids say, well, yeah, I see Dad wanted to be cremated, but I don't want to cremate Dad, they're going to bury Dad. And, it's not like the cops aren't going to come knocking on the door and say, you were supposed to get him cremated. If all 3 of them, they're the ones that are still alive, they're the ones making the decisions, they're going to do what they want to do, if they're all on board with it.
Yeah. That's
Now,
what
if
I'm
there's
saying.
a battle going on, then somebody might file a lawsuit to try and force one thing or another.
Do these power of attorney and stuff cross state line?
They should.
They should not.
They
Or
should. They
Okay.
should, yeah. I don't know why they wouldn't. In my experience, if a document was valid when and where it was executed, So if it's executed in Wyoming and it's valid under Wyoming law, then it should be given effect in other states as well. If it was invalid in Wyoming in the first place, if it didn't meet the requirements under Wyoming law, then they're free to disregard it in other states too. Yes, sir.
How often should you update your living trust? In other words, okay, we've got a living trust. How often do we need to maybe take it into an attorney and say, look this thing over, what do we need to change to stay up with the law?
Okay, so changes in the law, normally that's not going to invalidate a document that was executed earlier. It could, but typically the changes in the law are effective from and after the date of the change in the law. My advice to people, which I do not follow myself, is get the documents out and look at them at least once a year and think, has anything changed that makes this no longer what I want? You live long enough, sooner or later the answer will be yes, because things change. And a document that made sense 30 years ago might not make any sense anymore based on how circumstances are now. But I've seen it where people executed a will 30 years ago and they never looked back. And when they passed away, the family's looking at it like, holy cow. Well, I'm sorry, that's the last will. That's the one that's going to be given effect. So it's important to stay on top of that for those practical reasons that circumstances change. And sometimes what you wanted when you signed the document is no longer what you want.
Okay, thank you.
Yes, ma'am.
So I've seen where you can just download will documents or power of attorney documents online. Are those valid, legal, or not?
It matters what words are on it. I've seen situations where people had a document which would have been perfectly valid, except they did not sign it in accordance with law. And it's not a valid will unless it's executed in accordance with the Wyoming statutes in Wyoming for what it takes to be a will. It's not enough for it to say it's a will. It has to meet the criteria under Wyoming law to qualify as a will. So it's got to be signed under Wyoming law. It's got to be signed in front of two disinterested witnesses, meaning they can't have any stake one way or the other. They're not inheriting. They're not related by blood or marriage, typically. You got to have two disinterested witnesses. In addition to that, most wills also have a notary on there, and there's I swear language in the document. It's known as a self-proving document. Otherwise, in situations where a will is not a self-proving document, there's no sworn testimony that it's true. It was signed by the person. It was signed by two witnesses, and that's it. It can be in a situation where we want to probate that document. We have to bring those witnesses in to swear before the judge to the circumstances when the document was signed, that they were all present at the same time in the same room. It's not enough to sign it. Two people sign it now, and 3 days later, someone else signs it. That is an invalid document. And so without it being a self-proving will, then the judge is probably going to require those witnesses to show up and testify to the circumstances to determine whether or not it meets the criteria to be treated as a will. And if one or both of those witnesses is long gone, you might be in a spot where the document never qualifies as a will. So there's plenty of reasons to be leery about. There's documents available. There's always been documents available. There was will kits that were sold in stationery stores for years. There was will salesmen traveling door to door selling documents. And there's lawyers make a lot more money off of those things than they do from doing the estate plan themselves, because they typically have a problem with it. So my advice is get with a lawyer who does estate planning. I don't mean me, I'm just saying in general. Get with a lawyer who knows what they're doing. Have them do the documents. It's money well spent.
Does that make a difference if anybody objects? I mean, if you have something like that isn't notarized or something, but nobody in the family objects to what was there, is that?
The judge might object, because sometimes judges will take a hard look at the document themselves, and they're not obligated to roll over and declare it a valid will just because somebody asks them to. If they look at the document and they say, I know what the statute's saying, that does not meet the criteria, the judge might be the person who says, nope, I'm gonna do it. But most of the time, it's gonna be because people in the family are fighting and somebody's wanting things shoved one way and someone the other way.
So if you have a living trust, can you just put everything in that living trust? Do you need a separate will besides a living trust?
Good questions. So nearly everything can go in the trust. My experience is that IRAs, 401ks, things like that do not go in these kinds of trusts.
Property like, unlike, like real estate property, your home, like these acres I have in Minnesota, do you put your titles to your vehicles in a trust?
So here's how.
With your checking account, that's for savings.
Yeah, there's nothing inappropriate with putting all of those kinds of assets into the trust, and normally my advice is do it. Now, I have to qualify that from personal experience. I used to say universally, put your cars, if you're asking me, I'm telling you, put your cars in the trust. Well, I ran into a problem myself.
Did you trade them off?
I had a car that was titled in my trust, and my wife, she's a wheeler dealer, she found a car down in Colorado at a CarMax, I think. We drove down there to trade in that car, and we drove that car, and we thought, yeah, we're gonna trade it. Flopped the title down on the counter, and they said, oh, it's in your trust. We need a copy of your trust. And I said, you cannot have a copy of my trust. I'll give you a copy of the certification of my trust, which you're required under Colorado law to accept, and Wyoming law to accept. And they said, oh, no, we have to have a copy of the trust. Well, sorry, that's a private document, you're not getting it. So
if your husband and your name is on the title of each vehicle, are you pretty safe that way?
say that again.
If your husband and your name and your spouse is on the title of each vehicle that you own, are you safe enough that way, not to have to worry about probate or anything like that?
Again, the details are important. It depends on when the title was issued. It depends on what other words.
And/or,
Yeah,
is that a deal?
Forget about that one. But, and/or, that's a real ambiguous term that has no
I
recognized
know,
meaning in
you
the
hear
law.
people talk about that all the time.
Yeah. So there was a change in 2020. The Wyoming legislature changed the laws with respect to titling vehicles only. This doesn't apply to anything other than vehicle titles. And so if there's two names on the title and there's nothing in between those two names, or it says or, not and or, it says or, then either owner can transfer ownership without the other one, which I think is risky.
But then you're okay if one of them passes.
Well, if one of them passes away. You're also okay if it has both names and it says and it says joint tenants with right of survivorship. You're rock solid. If one of them passes away, the survivor it can get a new title, but then it's still outside the trust.
Yeah.
The other question you had was about a will. Having a trust is nice, but I don't do an estate plan without also having a will in a trust plan. But the will in that situation says whatever's not in my trust, put it in my trust. So that if there's assets that are outside of the trust, they still wind up in the control of the trustee. But if they've already been titled into the trust, then we avoid the need for a probate to make that happen. But having assets outside the trust can trigger the need for a probate to get them in the trust. And even if we don't have to have a probate, somebody's gonna have to make that happen if you die. Somebody else is gonna have to find the title. They're gonna have to provide paperwork in order to get that car transferred into the trust because the will says put it in the trust. So the simpler thing for everybody else is just to have it already in the trust. And bank accounts can be retitled into the trust. That makes them trust assets. Nobody needs to have a signature authority. I see this frequently. Somebody wants help from one of the kids writing checks to pay bills. So they make them a co-owner on the account. Do not do that. They don't need to be a co-owner on the account to sign checks. You can give them signature authority on the account without making them a co-owner. Yeah, but my preference would be for the checking account typically to be retitled as an asset of the trust. The trustees of the trust have access to that bank account. They don't They don't need to qualify. They might need to prove to the bank that they're a trustee, but they don't have to do anything special other than that to have access to those funds.
But don't they have to be on their account?
What's that?
Like my bank said, I removed some of my children from my account. And just to not create any. And then left the safe deposit box, and since I removed from the account, they cannot access when I pass, cannot access the safe deposit box.
Yeah, the safe deposit box is separate from a bank account, even
It
if
was
it's,
connected to the bank.
it can be the same bank, but
Yeah,
having a
it
safe.
was in a bank account, but since I removed it without realize, affected the access to the safe deposit box after the fact. So I had to have another, close that safe deposit box and open another one because the legality would not allow, because I removed it from the bank account.
Okay, yeah, I don't know the specifics of.
This happened another month ago.
Yeah.
About 6 months ago. The bank is.
You have a question in the back?
Yes, sir.
That affidavit of survivorship form, is that required if you have a living trust in one of the other passes?
No, if that piece of real estate is in the trust, then there is no need for an affidavit of survivorship for a piece of real estate that's titled in the trust.
Okay, is there a difference between a living trust and a revocable trust?
Two different names for the same thing.
Okay, thank you, sir.
Yes,
If I may, I have a question about the.
got a question? I'll get to you next.
Can you put a living trust as a beneficiary?
Yeah, I've seen that. You mean like on a bank account or something?
Bank accounts or IRAs or all?
Now, the IRAs, again,
Annuities.
IRAs, you need to touch base with your tax and investment advisors about whether or not that's a good idea, because that can trigger adverse tax consequences, which I can't comment, I'm not qualified to talk about, but you can technically do that, but whether or not that's gonna be a good idea is a tax issue. So you need to get the input from a CPA and maybe an investment advisor about whether or not to make a trust a beneficiary on an IRA.
Or how about an annuity, is that the same thing?
Annuity is a different thing typically, so I don't know that that would be a bad idea, but you gotta get specific information about that annuity and get the input from appropriate professionals, whether that's investment advisor or attorneys, about whether or not that particular annuity should be paid over to the trust.
Thank you.
Okay, just a couple more questions and then we gotta go.
So there was a question up here.
If I may, so the safe deposit box can be in the living trust addressing or access?
I don't know, that's a bank question, whether or not the bank allows that. You need to-
Like you said, I mentioned was rejected by them to close.
Yeah, whether or not a bank would allow the trust to hold a safe deposit box, that's a bank question specific to each bank. Yes, ma'am.
Did you sell your car?
No, we got back in our car and drove back home. So I was dead serious. You guys are you're not getting my trust.
Okay,
They didn't know
so,
who they were talking to.
Well, I didn't care.
so on the car thing,
Yes, ma'am.
so if I put a car in my daughter's name, which I did, I don't know whether I put joint tenants, I don't know what I did, but it's paid for, so I thought it'd be easier for her if I had her name on it. And then, when I pay off my pickup, put it in one of his names, whatever. So I just thought it'd be easier when I die for them, the title stuff. Is that okay? It's not the trust. Car's not the trust, Buick's not the trust. It's just mine.
Put a hand on it.
But, and
Well,
what's the cleanest thing?
it depends on what you want. If you're wanting to make a gift of that car, you can make them the owner of the car right now. You don't have to
Right,
remain.
that's
a
what I
co-
did. I just didn't, I don't want to hassle, it was a hassle when my dad died, because he had vehicles, and my name wasn't, so I didn't want them to have to do, my kids to have to go through that.
But you drive these cars.
Well, yeah, they're mine. I drive.
Your cars, but they're your kids' names.
No, mine and theirs, mine and theirs.
Yeah, well, that makes it part their car.
That's
so.
fine, it's not that worth that much, I don't care.
Okay.
But if it's Ann, is she okay? They can't sell it away from her? Or is the or thing make it so they can sell it?
It would depend on when was the title issued, exactly what does the title say. And so a way to be sure that there is the right of survivorship is to say joint tenants with right of survivorship.
So then nobody do anything until I die, fine. Yeah, I'll just drive around. To enjoy tenants with right of survivorship.
It sounds like you got specific questions that you need to, you probably need to consult with an attorney about that situation to get answers, because that's not general, just general. That's a specific situation.
But I don't know if you, just being married.
Yes, ma'am.
We're good.
If you designate a corporation as your trust, in your trust, do you have to let them know, like, let's say you're gonna use First Interstate Bank as your trust. Do you have to let them know before you're dead that they're going to manage your trust for you?
You don't have to let them know, but they might decline, and they're not obligated, just because you named them, they're not obligated to do the job.
And then what happens?
And then the trust has no trustee, and so someone would have to take action to get someone else appointed. Depends on how the trust is set up. The trust might be set up so that beneficiaries can elect a trustee, or it may be that someone's going to have to petition the court to appoint a trustee.
Well, if there are no beneficiaries, and let's say like, it's my trust and I die, and there's no beneficiary.
There's no point in having the trust if there's no
Well, if
beneficiary.
the trust was established when I was, let's say when I was about, he passes away and the trust is in my name. And I pass away and I designate the bank as my corporate trustee.
Yeah, well, in order for there to be a trust, there has to be beneficiaries. If there are no beneficiaries, then what's the point of having the trust?
Well,
It'd
the
be my-
beneficiaries would be like different, it'd be like the Shriners or something like
Okay,
that.
so they would be beneficiaries. Probably they would be able to find a way to get a trustee appointed.
But if the bank didn't take it and didn't look at it, where would that be? Where would I mean.
Not unless they're the benefactor. The bank would take your money. Make
Well, yeah, and I'm
make
good with
them the
that, like
beneficiary.
10% or whatever, to manage the trust, I don't have a problem.
I think, yeah.
Okay, I think we're out of time. Thank you very much.
Somebody else. So we had a question about how to get hold of Rick. I asked him to bring some cards. If you'd like one of his business cards, that's fine as well. He can meet you back by the pie. A couple of things that I want to make sure that we talk about for sure is the April 6th event. It's in this room. It's on a Saturday. It starts at 9 o'clock. And we'll have a light lunch. And we'll be done probably around 3. And it's a resource. It's a free resource to our community as well. And so we're going to draw for the book. I wanted to address, Sheila, I wanted to address your question with the insurance, with the Sheila. I wanted to, when you asked about if the insurance, is that considered an asset? I can only tell you from my point of view as an advanced funeral planner, when people come in and they say, I paid for my funeral at the funeral home, the funeral homes don't hold the funds like that. But what we do is we work with a company who has a funeral policy plan. And so the funds are put into a policy. So when I work with people, our funeral policies are protected from Medicaid. I can't speak to your personal insurances, whether term or life, insurance or whole life, anything like that. But I will tell you that particularly when people work with their local funeral homes, they have a person in place who can facilitate putting funds into a policy that is protected.
Yeah, I was just asking about life insurance.
Yeah.
I have a lot of life insurance.
And if it has value, if you were
Better have
called,
value.
if you called and you asked them, what is the surrender value or what is the
Yeah, I
face
know.
value?
Yeah, I get that.
A lot of people don't know that that's
Yeah.
something they can do, but I just encourage people, if you're paying on it or you have paid on it, be sure to call and ask them what that value is as of today. It may be quite different than what you expect for it to be, or it might be exactly what you expect. So, but that's what, one of the things that catapulted this was that we wanted to help people understand how important planning is on all these levels, but also just getting that resource out there to start asking questions. You guys have had great questions today. And so one of the final, go ahead, Sheila.
Well, I prepaid both my parents
Yeah.
and whatever was still Naker, I don't know what it was. And it was slicker than a whistle. It was so cool. So, I mean, so good. I'm thinking about going and paying for mine.
Those are usually the people that are first back to the table, or the people who have experienced a funeral that has been pre-planned and pre-funded. Because it takes basically the burden off your family members, and it gives you an opportunity to start recalling memories, to start the grief process, things like that, when you're not at the table discussing the, 175 questions to 125 in the first 36 hours after death.
It's a good thing to do.
Yeah, thank you for that. That's one of the big
Please, you
things.
have to go do anything else, too,
Yeah.
because you got that taken care of.
Yeah, exactly.
And don't do anything when you get to lose.
I counted how many people were here, so what I want you to do is count off, and then we're gonna draw. Because you're gonna draw, make sure it's legitimate.
Pick one, a number.
Rick's an attorney, can we trust this guy?
I would say,
Okay,
Yeah, see, he'll stop.
so you're 1,
2,
3,
6,
8, 9, 10, 11, 12, 13, 14.
15. Betty's 16, how about, Betty, you're 16.
17.
18.
19.
Did you say 20? Yeah, okay.
You put 20 numbers in there, or 21?
21, counting, yes.
Ready? Yeah.
She gets I gotta go with yours.
You get that.
Number 10. There you go. Okay, so again, this is one of my favorite books. Please, if you don't have it, you haven't read it, please read it. It is an amazing book. It tells you how much your life matters. It's a whole history about how one person changed the world.
The name of the book, please?
What's that? It's called The Butterfly Effect by Mandy Andrews. All right, so I'll bring your book back in just a second. Thank you so much for coming. Please. Rita, do you have something else with the bio, with the obituaries?
No, I'm okay.
You're good? Everybody is interested in obituary. If you haven't worked with Rita, work with Rita, okay? See you on the 6th. Thank you for coming.
Thank you.
You're welcome. A card? Okay.